go to speak to tomorrow. Yeah. She's got some on in the morning. She's probably about 10 o'clock. No, she spoke to you. And she's doing things there. I just don't know if she wants that. But a lot of them are just
They've never done it.
Well, he knows.
Can you take us in brief review? Good job, we can thank you. Mr. Cunnington, you're ready to Mr. Wrigley?
Yes. Mr. Wrigley, do you have in front of you a proof of evidence?
I can't hear. You can't hear?
I can't hear. Can you hear me now clearly?
Yes, better, yes.
Great. Well, I'll raise my voice slightly. Mr. Wrigley, in front of you, the document on which you have your left hand, is that entitled Proof of Evidence of Dennis Wrigley?
Yes.
Now, Mr. Wrigley, as that contains your name and your address, all I'm going to do is invite you to start reading the document at paragraph 1 through to its conclusion.
That comes as a surprise, but I will try to. Firstly, can I say, my name is Dennis Wrigley. I've lived in Flixton all my life, although I've worked in London and had offices elsewhere. And I'm 82 years of age and have been deeply involved in the life of the community here in this district in a variety of different ways, in churches, in national politics. I've worked at Parliament on a number of occasions, and also with, particularly with children and young people, and the elderly, and those who have special needs. So that is my position. I wouldn't be seen to be boasting, but I would be seen to be involved deeply in the life of the community in this district. Now, the second thing I wanted to say before going forward on this is that we are, at the moment, facing quite, I think, a crisis of community in this district. And the perceptions that people have now concerning what is happening are very, very serious indeed. So I must crave your permission just to do this before reading the document which I prepared.
Okay, we're going to come back to proof in a moment. Yes. And you'll read that. Yeah.
I just want to say that I had the opportunity of reading the document prepared by Paul Nicholas Singleton November 2012 for this public inquiry associates, in which in 1612 he says the Council's second reason for refusal is founded solely on the weight that should be given to public perception of the risk of adverse impacts on health. And then he follows this up surprisingly in the next paragraph by saying, I accept that such matters are capable of being material in this appeal, but conclude that they should be given minimal weight. Minimal weight. I just wish to emphasise that at the starting point, which I think would horrify most residents in this district.
Absolutely.
Now, the number that I was requested to speak from was...
Well, if you start from the beginning, you might find that
Right,
some parts in paragraph 2
Fine.
that you've already...
My involvement in the local
traced
community.
through. Yes, but
Okay.
let's start at 1.1.
Wonderful. Okay. This document contains a summary of my involvement in the life of the local community, the evidence and submission, together with notes and attachments and a life profile summary. I have to say I don't go into life profiles, forgive me, but at least you will know something about me when you read it. Now, as I said, I'm 82 years of age, and I've been very active in the life of the local community. And 35 years I was leader of the Flixton Fellowship Forum, a very strong group of young people and young adults who are extremely active in the life of the community in Flixton, Ernstone and Davyhulme. And they undertook very extensive work in the launch and maintenance of many social projects. For 25 years I was chairman of the Flixton and Ernstone Human Needs Scheme, which brought direct help to people in need, both in this region, this area, and overseas. And I was instrumental in the formation of the Barnabas charity, working with homeless and addicted in the Manchester city centre, which had its base in my office in Flixton. I coordinated the Trafford campaign on the rate support grant formula. This was a very controversial issue involving payments of many millions by taxpayers in Trafford. And it was highly controversial. And I arranged about 9 public meetings and a mass lobby in Parliament and negotiations with the Secretary of State. And we secured success. And Trafford Borough Council benefited very considerably from that. I led the campaign to build the motorway spur road.
Okay,
Now, I've been asked to read this, so I'm doing so. I don't
I'm sorry, I think it's a proof of evidence.
Mr. Wrigley, the document that's in front of you, that's not the proof of evidence that I suspect that the inspector has in front of him. Certainly not the proof of evidence I have in front of me.
Evidence and submission, is it?
Evidence and submission, that's it. Yeah,
Well,
if you can read from there.
That's fine.
That's
Okay.
Thank you very much.
Fine. I think I've got to finish what I said, namely that those various initiatives locally bore fruit. We were desperately concerned that each time undertakings were given, whether on the Davyhulme sewage works situation or whether it was the petrochemical development in Carrington, that the local community would not be affected at all. The various official bodies gave those firm undertakings, and in every instance the undertaking was broken. Right. It's beyond dispute that the communities of Flixton, Ernstone and Davyhulme have for many years been subjected to totally unacceptable, dangerous and excessively high levels of air pollution. These have been and remain a serious threat to public health. Public health statistics for this region show conclusively that those who live here suffer from a far higher level of respiratory and other diseases than those living elsewhere. There is a real...
I think there's a departure here from...
I'm sorry, this is 3.2 I've got here. Sorry.
So I suspect Mr. Wrigley has been provided with a document that is not his submitted proof of evidence. I don't know...
Somebody provided...
Well, if someone provided me, I'll read
so
it.
that you can read from that. Thank
This
you
is the
very
one
much.
I've been given.
I don't know what the provenance of the document before him is, but he can be supplied with one now.
So this is the one that everybody's seen, Mr. Ruby. So
I see. Okay, that's fine. Thank you so much. Can we turn to the paragraph I started, please?
Perhaps, Mr. Wrigley, if you turn to paragraph 3.1,
3.1,
which is directly beneath evidence and submission.
3.1.
Please.
It is of extreme concern that communities of Flixton, Elmston, Davyhulme and Stretford have, for many years, been subjected to unacceptable, dangerous and excessively high levels of air pollution, both industrial and from traffic. These have been and remain a serious threat to public health. One of the main sources of industrial pollution has come from Shell chemicals in Carrington. Flixton and Elmston is downwind of Shell. The plant was built in the 1950s and expanded over the years. But then production was scaled back. Shell made oil-based chemicals and polymers. Its flare stack used to light up the sky and was visible for miles, and smoke drifted towards Elmston. There was also gasworks in Partington, and when the UK converted to natural gas in the 70s, the new gas plant was built in Carrington, next to Shell Chemicals. Also, in Carrington, an industrial gas plant known as Air Products was built in the 1960s. Chemical and petrol tankers used to drive through Flixton and Elmston until the Carrington Spur Road was built. Carrington also housed a coal-fired power station, which was decommissioned in 1991. Ash from the power station was deposited on a huge hill in the downwind area of Flixton. Recently, a large paper mill has been built in Carrington, to be followed soon by a new 850 megawatt gas-fired power station. 1.8 kilometres away from the proposed VREP site in Trafford Park was the coal-fired Barton power station, which polluted nearby farms when the east wind blew. Because of the levels of pollution, they had to increase the height of the chimneys, building 2 new 100-metre chimneys. This power station was decommissioned in 1974 and demolished in 1978-9. Alongside it was an oil refinery known as Manchester Oil Refinery, which was also demolished. There is presently a long-standing large sewage works, United Utilities wastewater treatment works, which has caused serious inconvenience from unpleasant odours. The plant has striven to improve these over the years, and the smells are now less frequent. However, it now encompasses anaerobic digesters, 5 gas engines, and a flare stack. My friends and contacts in the many local organisations that I belong to have felt that the area has borne an unfair amount of pollution from industry. Public health statistics for this region show conclusively that those who live here suffer from a far higher level of respiratory and other diseases than those living in less polluted areas. There is a real and continuing threat to public health which cannot be ignored. I consider that our local community has long suffered from the effects of industrial pollution and its associated health impacts. The proposed incinerator will add to this pollution, the extent of which is unknown and, I submit, impossible to accurately model. Those supporting the proposed incinerator seemingly ignore the continuing high level of deposit of grit and particulate matter which these neighbourhoods have suffered for many years. Visual evidence of this is often seen in deposits on vehicles and long-term discoloration of hard surfaces. Frequently, following rain, the district is covered with a fine, gritty film. It is highly significant that in many parts of this district, hard surfaces which are protected by overhanging roofs contrast dramatically with the adjacent, discoloured and dirty surfaces which have been persistently subjected through particulate deposits over the years. With ample justification, residents are extremely doubtful about the claimed efficiency of cleansing, filtering and monitoring of substances emitted from chimneys such as that proposed. Their experience has been that over many years, promises and undertakings about standards have been broken. From my own past experience, it is my belief that they have little confidence in those responsible to protect their health and environment. I say that with due respect. The continuing high risk to children who are particularly susceptible to harm from atmospheric pollution, especially particulates, is extremely worrying for parents. They believe that any increased emission of dangerous particulates puts their families at higher risk. Levels of pollution should be reduced and not increased as is being proposed. Many people have already left this district because of intolerable atmospheric pollution. If their environment is damaged still further, many more will undoubtedly do so. Experience also shows that the proposals, such as that for the biomass plant, will inevitably have a damaging effect upon property prices in these areas. A poll in the local Streatham Emerson Messenger newspaper showed that 93% of readers opposed the BREP proposal. The Breathe Clean Air Group, to which I must pay great tribute, they have a petition of approximately 6,500 signatures, also opposing the proposal. It is clear that the overwhelming majority of all local residents have expressed opposition to BREP. The local authority is also unanimous in opposing it. There is now a huge upsurge of public concern by people of every political persuasion, by local community groups, by churches, by voluntary associations, who are all united in their total opposition to a development which they perceive to be potentially dangerous or deleterious. If the concerns of thousands of responsible ratepayers are swept aside for the purpose of private profit, then public confidence in democratic procedures will justifiably be gravely undermined. It's a matter of the utmost importance that all those in authority, and in particular the Secretary of State, are fully aware that on many occasions promises made to local residents on important issues have been broken. Over 50 years ago, they were told that the petrochemical plant in Carrington would not damage their environment. Yet, for years, local people were subjected to the emission of noxious fumes. Flixton residents were promised that the development would not affect local roads. Yet hundreds of tankers thundered through Flixton before public outrage forced the building of the Carrington Spur Road. In the 1970s and 80s, residents were repeatedly promised that the foul stenches emitted from the sewage works in Davyhulme would be ended. But these promises were consistently broken. Local residents are working hard, fighting for a better community, for less pollution, and an improved living environment. They believe that for too long they have suffered intolerable levels of atmospheric pollution. And there's now very widespread concern about the proposed biomass plant. This proposal has generated one of the largest movements of mass protests ever seen in this area. Now, the additional notes. Speaking in the House of Commons on this issue on the 27th of October 2010, I was there. Charles Hendry, the Minister of State of the Department of Energy and Climate, admitted a great deal of concern has been expressed about the effect on air quality, the natural environment, and the health of communities in the vicinity of an incinerator. Furthermore, he said, the involvement of local communities and their right to determine how they evolve is absolutely at the heart of this process. I want to repeat, he said, the involvement of local communities, you see, and their right to determine how they evolve is absolutely at the heart of this process. Because Trafford is an area that suffers from significantly high ambient pollution, part of the area was declared an air quality management area in 2005. It was reported in 2011 that the legal limits stipulated in the Air Quality Standards Regulations 2010 are already being breached in Trafford on a daily basis. On a daily basis, those regulations are being breached. Now, Dr. Hans Christian Rabe, who I understand will be addressing this inquiry tomorrow, he produced a research document entitled Child Health and Environmental Toxicity, giving background information in connection with the controversial proposal in December 2010. A copy is attached to the submission. In it, Dr. Rabe says, children are particularly vulnerable to toxic contaminants in the atmosphere. Flixton, Ernst and Davyhulme already have a high level of atmospheric pollution. An extreme caution must be exercised by those in authority to avoid making a bad situation worse. I submitted the attached document, a matter of great public concern, to the various relevant authorities in January 2011. I think you have a copy of that, Mr. Inspector. Many of the urgent questions put in the document, I think there were 12 in all, to a variety of local authorities, and many of them remain unanswered to this day. But that was over a year ago.
Thank you very much.
Thank you.
Mr. Kingston, do you have a question?
Good morning again, Mr. Wrigley. Mr. Wrigley, the only thing I want you to confirm for me is that when you quoted Mr. Charles Hendry, the Minister, in your proof of evidence, what you quoted is part of a much longer speech by the Minister in which he set out the government's view with regard to proposals of this kind.
Of course. I was fully aware, I heard it all. But this was a significant part of his contribution. And members of Parliament were very quick to pick up on the particular words he used about the influence of the local authority, the local community. This is why I included it.
Of course. Thank you very much indeed.
Thank you. Any re-examinations?
No, sir. Unless you have any questions.
Okay. Thank you very much indeed. That's all. Yes, that's all. Well, I'm sure. But what you said is very good. Thank you. And I hope you have a good day in London tomorrow.
Thank you so much. Thank you for allowing us to be brought forward.
Okay, so next I think we're to hear from Dr. Davyhulme. Yeah, okay, so we'll have a short break while Dr. Holman takes her place, and we can let the doctor. Just a brief. Okay, well, good morning, Dr. Holman. Welcome to the inquiry.
Dr. Holman, do you have in front of you the following documents? The first, the summary of your proof of evidence.
That previous witness said that as well, which I find surprising, but that can hear perfectly well.
It depends where you're sitting. The sound is dead in some parts.
Right. Right, well that's
quite lively in others.
Quite different, isn't it?
That's certainly a problem for the witness, isn't it? So perhaps, if you can speak.
No, don't I'll just raise my voice.
No, but that's fine. If there's any difficulty in this case, we'll do something else.
I suspect unamplified, Dr. Holman, you can hear me anyway, can't you? Yes. Microphone very necessary.
Yes, sure.
That way. Dr. Holman, in front of you, just so it's clear, you have the summary of your proof of evidence, then the full text of your proof of evidence, and the appendices to that document. Very grateful. Now, perhaps you might begin by taking you to the summary of your proof of evidence, rather than reading out the first paragraph. If you introduce yourself to the inquiry and perhaps give a short summary of your professional experience and qualifications and indicate why it is you're qualified to give evidence on the issues before this inquiry.
Okay, so my name is Claire Holman and I'm a principal for an environmental consultancy called Davyhulme. We're a global environmental consultancy and I lead our European air quality practice. I have worked on air quality for about 30 years, following my PhD in air pollution. It focused on ozone formation in the troposphere. The reason why I mention that is it's of relevance to some of the issues that may be raised later. I'm a fellow of a number of professional institutions, including the Institute of Air Quality Management and the Chartered Institute of I'm a Chartered Environmentalist and Chartered Scientist. I chair the air panel of the Chartered Institute of Water and Environmental Management, and I believe this afternoon that I will actually become the Vice Chair of the Institute of Air Quality Management. I've served on a number of government committees. I have served on what was then the Department of Environment, Quality of Urban Air Review Group for a number of years. I have been a member of the Southwest REPAC of the Environment Agency. The REPAC is a statutory committee that's required to be held by the Environment Agency, and REPAC stands for the Regional Environmental Protection Advisory Committee. I served 2 terms, and then I was not a member for a number of years, and then I was approached by the Environment Agency to reapply, and then I served a further 3rd term. So I've been instructed by the Green Clean Air Group on the 5th of October of this year to provide evidence on air quality.
Now, Dr. Hulme, what I'm going to invite you to do is to read from the beginning of paragraph 2 the summary of your proof of evidence. I don't intend to interrupt you whilst you read, but I may come back, and I will come back, to 2 or 3 paragraphs in your main proof of evidence, which I'm going to invite you to amplify for the benefit of the inspector.
So starting with section 2 on planning policy, and I must first of all say that when I prepared my proof of evidence, that the core document list I had was not the final version. In fact, I think there's possibly been an even further one than I've actually got now. So some of the core document references might be incorrect, and my apologies for that.
Well, I tell you what, Dr. Hulme, when you've read the summary of the proof of evidence, I tend to take you to a couple of paragraphs, at least in your proof of evidence, where there may need to be an amendment to the core document references. That they're only slight, but I'll do that for you.
So under planning policy, paragraph 2.1, the National Planning Policy Framework provides clear guidance that air pollution, including cumulative effects, is a material planning consideration. Decisions must reflect EU obligations to prevent new development from contributing to unacceptable levels of air pollution and should be appropriate for its location. The control of processes or emissions from large plants, such as the Barton Renewable Energy Plant, is the responsibility of the Environment Agency, and therefore I have not covered these issues in my evidence. I have, however, discussed DEFRA's guidance on the assessment of the impact. Policy L5 of the Trafford Core Strategy states that development that has the potential to cause adverse pollution will not be permitted. The EU Air Quality Directive sets limit values for nitrogen dioxide to be achieved by the 1st of January 2010. I shall use the short abbreviation for nitrogen dioxide and call it NO2, which is acceptable.
Yes.
The NO2 and AQOs is the air quality objectives, and the EU limit values are the same, but the AQOs have an earlier compliance date. They had to be achieved by 2005. Local authorities have a legal duty to work towards the air quality objectives. The Greater Manchester Air Quality Management Area covers the main roads within the region, including the M60. The site of Brett is adjacent to the AQMA, and the impact of Brett covers parts of the AQMA. Along the M60, close to Brett, concentrations of particulates will be more than 50% above the limit values. Turning to significance, the Institute of Air Quality Management and Environmental Protection UK guidance on significance criteria is used in the ES. An important element of the guidance not applied in the ES is the need to use professional judgment to determine the overall significance of a development. The DEFRA's environmental permitting guidance. The DEFRA provides guidance on the implementation of the European Directive 2008/1/EC on integrated pollution prevention and control. It requires consideration of how much the installation is responsible for the exceedance of the EQS, which is the Environmental Quality Standard, and the likelihood of remedial action elsewhere. where a new installation makes a minor contribution, therefore considers that it would be normally more desirable for regulators to work together to control the main source of pollution. So uncertainty. It's important when reviewing predicted air quality data to understand that there is uncertainty which is difficult to quantify. For example, using different models will give different results. The EA, Environment Agency, has rejected the applicant's use of the chemistry module in the ADMS model, and therefore my evidence only concerns or considers the results obtained using the agency's preferred approach. And here I've referenced the Annex 5 of the EA decision, but it's CD 67B is the final decision. The applicant should have presented the limitations and uncertainties of the modelling in the ES, including the results of sensitivity testing. Without this information, the results cannot be regarded as necessarily worst case. There are also uncertainties as to the baseline conditions. I'll now turn to baseline air quality. The Greater Manchester AQMA has been declared due to emissions from the main roads in the area. The ES considered that there was sufficient data available, so no measurements were commissioned. Given the sensitivity of the area, in my opinion, the applicant should have undertaken some form of monitoring and modelling to characterise the air quality in the area. The ES selected the ECHOS monitoring station as the most representative of the background concentrations. I do not agree that this site is representative of those parts of the AQMA closest to the major roads. The ECHOS station is defined as an industrial urban site and is located approximately 2.5 kilometres from the site and about 140 metres from the M602. No evidence was provided justifying the use of this site to represent background air quality, nor was the industrial sources identified. The ES presented data for Salford Council's diffusion tube roadside site at 673 Liverpool Road. I understand that this is the only long-term diffusion tube within the relevant part of the AQMA. Annual mean concentrations at this site were in the range of 58 to 68 micrograms per cubic metre between 2005 and 2009. No comment is made in the ES about these concentrations. Due to the influence of the major roads on the spatial variation in NO2 concentrations, the applicant, in my opinion, should have undertaken their own monitoring to supplement the data from Liverpool Road, and then model the concentrations in the area, verifying the results by comparison with the measured data. And then turning on to the significance of the breadth impact. The ES concluded the impact of the plant would therefore be measurable based on the EP UK guidance. The IAQM criteria on which the EP UK guidance is based requires the level of... This doesn't actually quite make sense, does it, this sentence? But what it should say is the IAQM criteria used to assess the level of significance depends on the background concentrations. 673 Liverpool Road is well within the 0.4 microgram per cubic metre contour if you look at figure 12.4 of the ES. And therefore the impact here, where the measured concentrations are over the AQO and the EU limit value, is a small adverse impact. There are likely to be a large number of other properties where the impact will be similar. The NO2 AQO EU limit value has been exceeded by up to 70% at Liverpool Road, and therefore it's going to be very difficult to reduce the concentrations to acceptable levels. This is reflected in DEFRA's modelling, which shows that limit values will not be achieved until 10 years after the directive's compliance date. The impact on an additional source will be greater than if the concentrations were just above the AQO EU limit value. Taking into account that the Air Quality Directive aims to maintain air quality where it's good and improve it in other cases, and that the MPPS requires planning decisions to reflect EU obligations, it can be concluded that the overall impact is a substantial adverse impact, as it worsens a non-compliance of an EU standard. However, the uncertainty surrounding the background air... Given the uncertainty surrounding the background air quality, but the probability that at least some of the area within the 0.4 microgram cubic metre contour is well in excess of the AQO EU limit value, and that there is a need to reduce concentrations, the location, in my opinion, is unsuitable for the proposed development. And then turning to the DEFRA's environmental permitting guidance, the EA has recently concluded that the NO2 concentrations with the plant could exceed the EU limit value, but due to the small contribution the plant will make, that the plant should be permitted. DEFRA guidance states that where a new installation would only make a minor contribution, it will normally be more desirable for regulators to work together to control the main source of pollution, ensuring the environmental standard is met. However, as compliance with the EU limit value will not occur until 2020, it is too late for adequate remedial action elsewhere. So turning to cumulative impact. The ES concludes that the cumulative impact of BREC with these developments is not a concern. This is the other developments in the area. However, the ES failed to adequately consider the cumulative effect of the current traffic with the plant or the impact of recent and future local developments. In conclusion, the appellant has used incorrect data to define the background concentration in the area surrounding BREC and have therefore wrongly concluded that the air quality impact of the plant is measurable. It is likely that parts of the area impacted by BREC exceed the AQO EU limit values, and in some locations by a wide margin. The Air Quality Directive requires improvements in air quality and achievement of the limit values by 2010. DEFRA estimates that compliance will not occur until 2020. Measures are required to reduce the concentrations, not increase them, even by a small amount. In my opinion, it is not consistent with the requirements of the NPPS and the local plan to permit development that will add to the NO2 burden in this area.
I'm grateful. So as I indicated, if I can just take Dr. Holman to a couple of paragraphs in proof of evidence. The paragraph I was thinking of initially, Dr. Holman, is 2.1.7, which is at page 4 of your proof of evidence. Now, there you refer to the NPPF, paragraph 124. Why do you make that point at that paragraph?
I believe that the EU limit values are exceeded in the area, and I think that is confirmed by the documents that DEFRA prepared for submission to the European Commission. The document was subsequently rejected by the European Commission because it didn't show compliance by 2015, which it needed to do. The National Planning Policy Framework requires the EU obligations to be achieved. And it is obviously not being achieved, and therefore I can't see how it's consistent with the National Planning Policy Framework.
Now, you just mentioned the EU Air Quality Directive. If you turn to paragraph 2.3, and cast your eye over the subparagraphs 2.3.2 and 2.3.5, 2.3.2
Yeah.
and 2.3.5.
So Article 1 of the
What, forgive me, what points is it there that you'd like the director to take from, Inspector of Economics to take from?
Well, on 232, Article 1 of the directive makes the point that you need to maintain air quality where it's good and improve it in other cases, adding to the concentrations in this area where you've already got a very large season. It's not improving it. And in terms of 2.3.5, the UK government submitted to the European Commission an application to postpone the date by which the NO2 concentration needs to meet the limit value. They're allowed to extend that date to 2015. They applied for the Greater Manchester urban area. The document shows that full compliance in the whole area would not occur until 2020, and therefore the European Commission rejected the application, and the UK government withdrew their application for the Greater Manchester urban area. And I do have in my appendix a very brief extract from that, the European Commission's decision on it. So the argument is that it's particularly bad in Greater Manchester compared to maybe some of the other areas in the United Kingdom.
I did say I'd give you the opportunity to correct one of the references to the core documents, but you also may like to comment upon the paragraph in which that correction is to be found. If you turn to paragraph 4.2.6,
So 2.4.6.
if you could, the document there, which is described as CD3A, I think is now CD5.
4.2.6.
Sorry, thank you. So 2.4.
4.2.6.
Sorry. I'm going now. Thank you.
I just dealt with the minor matter of the correction of the core document reference, but whilst you're there, again, what point are you making in that paragraph?
Okay, so the reference, it should be 5A rather than 3A to the core document. I don't want to expect it to turn to that document.
Yeah.
5A.
Yeah.
The environmental statement, and it's chapter 12, volume 1.
Yeah. I've got it.
And it is figure 4.5.
Figure what?
4.4.
That's 2000.
This is the predicted annual mean NO2 concentration using the 2000 meteorological data and the EA guidance factor. And if you were to, and unfortunately it's quite a small diagram and it's quite difficult to see, but if you look at the where Tyndall Street is on there,
Yeah.
but go down to the next coloured contour, which I believe is probably 0.8, lying just to the southwest of Tyndall Street. It's not very clear, but actually there are a number of references within the area that encompasses that 0.8 contour.
Yes, yeah.
If you look to the east, sorry, to the west of the motorway, I believe that is Wilford Street and around that area. I don't know whether you have been around there.
I've been to Tyndall Street. I haven't specifically seen Wilford Street, but I know that well.
So that's just, and then there's some houses on the other side. I think it's called Rook Street on the other side.
They're all on the eastern side of the motorway, is that correct?
Rook Street is on the eastern side. Wilford Road is on the west side.
All right.
So there are a number of dwellings there now. Exactly exactly how many is quite difficult to see.
Sorry, if you'll forgive me, Dr. Hall.
Sorry.
Forgive me for interrupting, but I don't want you to proceed on a false premise. That the area you're talking about, I'm told, is the 0.6 level, not 0.8. I appreciate the difficulty of interpreting the colours.
I'm not sure that's true.
Well, you
No,
carry on
it's not.
if you like to, but I'm merely reporting to you what Mr. Edison is telling me as the result of the outcome of the model.
Okay, well,
Can I just...
we do need to get to the bottom of it because sorry?
Shall I just come and show you what I mean? Would that help?
I can see a 0.6 contour further out from the circle, I think that Dr. Holman is referring to. So it is. No, I think, I think I've got that. So you were correct. Yeah.
Sorry. We're talking about this contour here, which is 0.8.
I know which one. Dr. Holmes, would you like to continue?
Sorry, yes. The point that I wanted to make was that when the modelling was undertaken, a number of receptors were chosen, and it is a large number of receptors. And I would imagine, and this is I don't know, but I would think that what's happened is that the various different residential areas have been identified, and probably the houses closer to the plant have been used as a receptor. But what they haven't done is they report the data, the ES reports the data, focusing quite a lot on Tyndall Street. What it doesn't do is focus on those areas where the concentrations are even higher.
You referred to the Liverpool Road monitoring station, or the Institute. But you wouldn't regard that, or would you regard that as typical of the area?
One of the things I believe is that the applicant should have done some modelling and some monitoring in the area to define the concentrations across the area. I don't believe that Liverpool Street concentrations are representative of concentrations, say, in, I don't know, Langdale Drive, or even possibly in Tyndall Street, because that monitoring station is very close to both the A67 and the motorway.
So that would give higher...
It will give higher concentrations.
It would prevail throughout the area.
But my concern is that we just don't know exactly what the concentrations are within the air quality management area, even outside for that matter. And without knowing that, really what you should be doing is you should be calculating the baseline conditions and then superimposing your contours on top of that. So you know it is at different points within the study area exactly what the impacts are, what the background concentrations are, and what the impact will be with the development. And I just feel it's inadequate because it doesn't do that.
Okay, thank you, sir.
Dr. Holland, will it assist you? I don't know that this photograph has found its way into the bundle with a reference. It's generated by the applicant, I understand.
Well, if you can give me a reference where I can see it, that's fine. Otherwise, it needs to be...
We may have to create a reference, but I don't know if it has one.
Yes, it was. No, I don't know that it was specifically numbered because.
Tuesday morning, I don't think it's made its way to me. I don't
think it was sent to the inspectors, and there's another one coming now.
I don't know if this assists Dr. Holman in giving a pictorial elaboration of the explanation you're giving to the inspector, but
so this is Liverpool Road.
This is Liverpool Road, and this has been submitted by the applicant. Unfortunately, there is a slight mistake on it. So you can see where Liverpool Road is and the motorway junction and roundabout for of the motorway junction.
Do you want to tell me what the mistake is?
Yes, can I just...
Well, you have to point it out to everybody if you're going to do that.
If you can just hear me, but I would just... The diffusion tube is just that it's on this post. It isn't. It's actually on this row, this building here, on the side of that building, which is about half a metre of the building.
I can't see which building you're referring to.
Sorry.
Is it?
Building, and it's about a quarter of that.
Can you just go to Mrs. Kingston and the other secretary? Sorry to make you run about, but
It's going to get a bit exciting. It's actually the gate that's around the corner of the building. It's like a metal net, and it's actually so it's not on the ground. I can understand it. It's not like it's going right inside there.
Have you got that, Mr. Cash?
I know that.
You know that.
I'm not sure the right would introduce it. It hasn't been introduced on. But it does really show, it shows quite clearly what sort of location it is in terms of whether
It was more the position of the housing to which I was drawing your attention, Dr. Holmes.
Ah, yes. Yes, thank you. Yes, as Mr. Cunnington has just raised my awareness to, what this shows you is Wilford Road, just caught off at the bottom left-hand side. So just here, this is Wilford Road, this road here.
Oh, yeah.
And this house is incredibly close to the motorway. There's one here.
I have actually been down there, in fact.
Yes,
So yes,
and because you can see this gantry.
Yes. Yes, I have seen it.
And then Laburnum Avenue, and there's a number of other, and this Brook Street here on this side. Thank you.
Now, staying on page 13 of your proof, if you cast your eye down to the last paragraph on page 4.2.11, there's, I suspect, a date that you want to correct, but whilst you correct that date, if you could also tell the inspector the point that you're making in this paragraph.
Yes, my apologies. This should say August 2011 and not August 2012. The point I'm making here is that the Breathe Clean Air Group did some diffusion tube monitoring over a month in 2011 at 21 different sites in the local area. And although 1 month's monitoring data will tell you nothing about whether or not it complies with an air quality objective or EU limit value, what it does do is provide an indication of just how variable the concentrations are across the area of interest. And I think I have some data in my appendices.
Your appendices?
Yes. Yes, this is figure 7.
Have you got that, or do you want me to take it that you've got it?
Appendix?
It's figure 7 within appendix 1, probably. Appendix 2 might be.
Okay.
And what figure 7 does is show you where the locations are. And then there should be some data as well to show it.
Do you have this one?
I've certainly got the figure.
I'm trying to find the data, sorry, I've split the tables and figures, and appendix 3, table 3 is the data that's related to that.
Yeah, I've got it.
And what it's showing you is that the concentrations vary significantly across the area. And that's sort of the only point I want to make. I mean, somebody who's not familiar with air quality data might think, oh, well, some of these are well above 40 and therefore the objective is exceeded. I wouldn't say that. It's 1 month's data only, but it does show the variation in the area.
that goes from A1 to G3.
Yes.
Direction.
Yes, and you'll notice that, say, the monitoring is done at different types of locations, from an urban background roadside to a curbside. Those sorts of definitions are included in, I don't know what the core documents number is, I'm sure there is one. It's the Local Air Quality Management Technical Guidance, which is core document 140, would define those. I don't know whether you want me to find a reference to that.
No, I can look that up.
In there you'll find, I think Annex 1 is on monitoring, and you'll find those definitions in there as to what.
The highest recorded ones here are curbside.
Yes, which is typically 1 metre or so from the road.
And final point, paragraph 5.2.6, if you would.
So this is the point I've made previously, which is taking into account that one aim of the EU Air Quality Directive is to maintain air quality where it's good and improving it in other cases, and that the NPPF requires planning decisions to reflect EU obligations and statutory requirements. It concluded that the impact is a substantial adverse impact. And just to add to that, obviously this is taking out of context some of what I've said before. Using the Institute of Air Quality Management and the EP-UK significance criteria, the impact is a small impact in terms of the magnitude of the impact. But the guidance requires you to look a little wider than just in relation to what the air quality concentrations are, but look overall as to how much exceedance is there in an area. We know that at Liverpool Road, concentrations up to 68 micrograms per cubic metre have been measured, which is very significantly above 170% of the EU limit value. And where it's very, very high, I believe that you need to take that into account in determining what the significance of the impact is. Now that
Is that an objective assessment, or is that a matter of judgment?
It's a matter of judgment based on criteria set out in the Institute of Air Quality Management significance criteria document. Which requires the use of professional judgment.
I don't have anything else at this stage.
Okay, thank you very much. Mr. Kingston then.
Good afternoon, yes, Dr. Holman. You were instructed, you told us on the 5th of October 2012. Could you tell me what documents you were provided with, please, when you were instructed?
Ooh, I don't have a list with me, I'm afraid, but there are certain documents that I was not supplied with, including the addendum to the ES, which I have now seen.
Could you just split the microphone? I'm so sorry, just split the microphone.
Oh, sorry,
The
you're not hearing me.
stick.
Okay, sorry. Can you hear me now?
Yes, I can. You were not supplied with.
I don't have a list with me of the documents that I was supplied with. I was not supplied with the addendum to the ES.
Well, that's either of them, apparently. You were not supplied with either the February additional information or the addendum to the ES in September. Is that right?
Can you tell me what the core document is of the one?
Core document 15B and core document 23.
I don't believe I was.
No, I don't, to be frank, Dr. Holman, because I know you, I'm confident that you weren't, because I think you'd have said some of what you've said if you see those documents. It's therefore, from my point of view, very important that the inspector understands that some of what you've said, and I'll take an example, and I mean you know this closely at all with this, for reasons I'm sure you appreciate, but some of what you said, for example, paragraph 7.3.3, you now know, and I can see from your face that you have read it, That is, I stress, I attribute no blame or anything to you, but that is simply not correct.
You might like to know that I'm reading the margin now done.
No, done. Well, I'm going to ask you to note that, and I've structured my cross-examination to respect the fact that Dr. Holland's approach is based on the two documents that are missing were not just also randoms, they were directly responding to questions, important questions raised by the Council's own pollution control team and important questions raised by the agency. And since much of that was about air quality, they really were very significant additions to the evidence base. You referred a few moments ago, Dr. Holman, to the work that the Breathe Clean Air Group has done with regard to air quality. Some of that work was subject to review by the Council's pollution control team and also to review by the agency. Have you seen what the agency said and the Council's pollution control team said about the Breathe Clean Air Group's work that was submitted to the Council?
I understand that there's been two documents submitted. One is the one that I have referred to, and there was an earlier piece of work that was undertaken. Is that what you're referring to?
I think it was the earlier piece of work, but let me make sure. And we think there were more than two submitted. But the important thing, have you read the report to committee?
I have read the report to committee.
Just take
which
it
number
up.
is it?
It's called Article 46. This is the report for the 10th November 2011. So, have you got a page number version?
No, I don't have it.
That's all right. It's a rare document with page numbers on it.
I don't have a date on it. I presume it's the right document.
Let's try from the front page of it then. Does it say on the front page at the top, Ward, Davyhulme West, 76153, full, 2010?
It does.
There you go. Right. The latter part of the document has numbered paragraphs. You have to turn on a bit because all the consultation bits don't have numbered paragraphs.
And that.
And if you could turn on in the numbered paragraph section, paragraph 74. This is where the Council considered the Breathe Clean Air Group representations. And they set out the documents that have been submitted to the Council: response to the planning application, monitoring of ambient pollutants to Davyhulme, monitoring of dioxide, yes, Breathe Clean Air Group, two responses to the Fichtner report produced on behalf of the applicants. Yes?
Yes, I'm with you.
And you're aware of presumably all of those documents, are you, from the Breathe Clean Air Group?
I am.
Over the page, the Council's officers, paragraph 75, refer to the fact that the assessment of those reports is set out in a detailed report found in the application file. Broadly, the pollution and licensing team has concluded that the measurements and techniques forming the basis of the group's report are inappropriate and not fit for purpose. The traffic air quality strategy is competent and fit for purpose, and the group's report is based on serious misunderstandings of the air quality regime. and a number of technical issues raised by the group report need to be rebutted. Have you had the opportunity of seeing the pollution and licensing team's detailed assessment of the work?
I have seen it, yes.
Yeah. Then you'll be able to tell me whether or not you agree with their conclusions in paragraph 75.
It says there are a number of reports here. As I mentioned previously, I believe that there were 2 monitoring reports issued. One was the initial monitoring report was not done to normal standards that you would expect to be done, say, by an air quality consultant. I think what's happened is it's a community group that has used the resources it has available, and unfortunately the work has not been done, let's say, to the required standard. The second piece of work, which is the one that I refer to in my evidence, is the monitoring of nitrogen dioxide using diffusion tubes, using a UCAS accredited laboratory, using very standardised methods, and I think that we can give far greater weight to that report than we can to the initial one.
Yes, that might be so that you give greater weight to it, just the question of how much, because if we go to the end of this section of the report, paragraph 91, Dr. Holme, perhaps I should say that the in-between paragraphs, that is between 75 and 91. 75 and 91. I took Mr. Watson on behalf of the authority through yesterday, so the inspector's been taken through those once, and I wasn't proposing to do it again, so unless you'd like me to. Where the detail is set out, paragraphs 76, 79, 81, and so on. But if you go to paragraph 91, that sort of brings it all together. For the reasons set out above, the findings of the group report and subsequent submissions are considered neither to offer convincing reasons to oppose the proposed biomass plant nor compelling reasons to refuse the planning application. And that conclusion was supported by a full and detailed report which you've seen from the pollution and licensing team, wasn't it?
I don't quite understand paragraph 91. I'm sorry to appear slightly ignorant, but they refer to the CAG report. I just wondered which of the reports they were referring to. If they're referring to the initial monitoring report, then I would agree that it doesn't provide convincing evidence of the background concentrations in the area.
Just read the next 3 words after report.
And subsequent submissions. I believe that the energy diffusion tube monitoring that was undertaken by the group is valid.
Well, you've indicated what limitations you think it has in terms
I think it has limitations, but in terms of actually providing an indication of the spatial distribution of pollution across the area, showing that there is huge variation, I think it's fit for purpose.
Those are the ones you referred me to earlier. So those are what you're saying, that's the second survey, the results of the second survey.
And if we look at what the Environment Agency has said, they took a similar approach. Perhaps I should ask, have you seen now the final permit and the decision document? You have. And you've read, therefore, the Environment Agency's response to...
I can't remember explicitly what they said. If you'd like to take me to the paragraph, I'd be grateful.
Yes, page 121. You'll see the agency referring in the right-hand column on page 121 to both studies, I think. Is that right?
No.
That's how I understand it.
No.
And the agency said when we reviewed this report, found many inaccuracies and discrepancies that brought into question the conclusions drawn and validity of the report. These included the instrument not being purpose limited survey period, potential issues with the gas blocks, incorrect measurement and reporting of nitrogen dioxide, the issues with the measurement of particulate. We're satisfied we've fully considered impacts on air quality as we've described in the main body of the document. And if you turn over the page, they go on then to deal with other group submissions, including some familiar papers from America and submissions with regard to greenhouse gases, filters.
I think you've lost me actually.
Oh.
Sorry, I was there with you on page 121.
Well, if you go over the page to 122, there's a short bit. Yeah, you've got it there. I can see it now on the right-hand side of the page. You've got there at the top. It says several other submissions from the group were made as follows, and then on the succeeding pages, those are addressed by the agency. Yes.
This is in terms of all the various health impact studies that were.
Well, a wide range of matters, not just health impacts. The group has raised a wide range of issues, and that continues over page 124, 125, 136.
I'm with you.
Right through to page 128, where the agency concludes, and that's a health effect matter. So the agency making it clear what they have reviewed, and clearly, as you've seen from the decision document, taking a view with regard to both the accuracy of the information and its usefulness from their point of view.
I'd just like to draw the inspector's attention to what they actually say on page 121. The paragraph that you read out in the right-hand column.
Yes.
Documentation. Could somebody provide me with one? Sorry about this.
This is called document 67.
7B, I think.
B. Is that the final one? Thank you. Yeah, you take that back. Sorry about that. Thank you.
So we're on page 121.
Yes, and you wanted to point something out, Dr. Horn, from page 121.
So Mr. Kingston read out the paragraph on the right-hand side of this column, of this table. This refers to the first report. So it refers to the paragraph on the left column, which it's next to. It does not refer to the second study.
I don't, with all due respect to you, this is the agency's response to both the documents listed, isn't it?
No, it's not right.
So I wonder if I could just be allowed to ask the question without having to deal with interruptions.
Yeah, you can certainly ask the question, and
without
again,
interruptions.
we need to establish it.
Yeah, thank you. Dr. Holman, one of two things has happened then. The agency have either listed the second report and decided that they wouldn't provide any comment, or they've provided a comment against both reports, which are on a perfectly fair reading what they've done, isn't it?
I'm afraid that my interpretation of that paragraph is very different to yours, Mr.
I'll let Mr.
It specifically says, the comments it makes specifically relate to the Environment Agency's concerns about the first report.
But limited survey period, have you not yourself raised a point about the limited survey period in the second report?
The original study was for less than 24 hours. It was not a month. So that's what they're referring to there.
And the answer to my question, Dr. Horton?
There's two different surveys. One
No,
of
I
which
haven't
was...
asked you about whether there are two different surveys. I asked you a question as to whether you have raised concerns about the limited survey period of the second survey.
Okay, sorry if I misinterpreted you. I have tried to explain to the inspector the limitations and also the value of the second study.
Including drawing attention to the fact that it was a limited survey period and therefore had that limitation.
The limitation is we cannot compare it with an annual mean air quality objective or EU limit value.
Just that. Thank you. Your overall conclusion, Dr. Horton, if I go with your proof to paragraph 8. Point 2.2.
So I'm just trying to sort out my documents. Try and get them completely in order. Sorry, which paragraph was it?
8.2.2, page 21. Your overall conclusion, EU limit values are exceeded within the AQMA. DEFRA's modelling confirms very high roadside concentrations close to the motorway. In my opinion, this would not be consistent with the requirements of the framework to permit development that will add to the nitrogen dioxide burden in this area. That's a sort of closed for business conclusion, isn't it?
Yes,
You should not have any other development that would add to nitrogen dioxide in this area.
Well, I would just say that, I mean, I'm not a planner, so I'm not saying that there should be... I do understand the planning system is about weighing up pros and cons. This is a comment in relation to air quality, and when a planning decision is made, whether by a Secretary of State, by an inspector, or by a local planning authority, they're weighing up lots of different issues. But in terms of air quality, I believe that it should be given very significant weight, because the EU limit value has been exceeded and you're adding to the concentrations. Sorry, I haven't answered your question, I don't believe.
No.
I think your question was...
I've got used to it. Not with you, it's not.
I don't think we do it deliberately.
Well, not in your case, I'm sure. But your paragraph 822 is, in air quality terms, a closed for business in Trafford. So let's deal with this location. That paragraph is telling us such is the state of air quality in this air quality management area that any development that adds to the nitrogen dioxide burden should be reviewed.
I would answer that by saying that every planning application should be reviewed on its own merits. There are some planning applications which have to be in a particular location. So, for example, the coal bed methane plant. Minerals are where they are, and development for minerals have to be where those resources are. I don't believe that there is any reason why this plant needs to be particularly in this location.
That's the answer to my question again. In relation to developments, let's take a major offshore development, which is, in the terms you just described, put loose. On the basis of your paragraph 8.2.2, no such developments should now be permitted if they are going to produce any increase in the nitrogen dioxide burden in this area.
You use the word any. I think you just need to assess each development on its own merits. I don't think you can have a blanket answer answer to your question. An office development could be a car-free development. It could be located near, the tram. It depends on where it is and whether it's in the right place. You can't just say that you can't have any development. I don't believe that you can completely sterilise an area because of air quality, but I think it's a consideration. It's an important consideration. It needs to be given considerable weight in the decision-making process.
At the beginning of that paragraph, you said, you used the word any. And the upshot of this is quite clear, isn't it? That the planning system, indeed air quality management, recognises that negligible increases are something that the system has to cope with. Otherwise, the whole of the planning system in our major cities in this country would grind to a halt. That's the reality, isn't it? A straightforward yes or no would help me. And Mr. Richards, point of view of writing a note, I think my question, I know it's awkward, Dr. Holman, and I appreciate that it's awkward. But my question is quite, I believe, quite fair, and I believe quite straightforward, and I would like you to answer it, please.
I don't think it's straightforward to answer it. That's the problem.
Okay, well, I think
There we are, so you'll have to judge that. Let me just test the proposition which I put to you just a few moments ago, but by going in your proof back to paragraph 2.6.4. And page 8. Thank you. is grappling with the same issue. It tells us for a new installation, if the necessary emission limit values cannot be met, then the permit must be refused. However, there may be ways to reduce emissions from other sources. Where a new installation would only make a minor contribution to a breach of the community environmental quality standard, it will normally be more desirable for regulators to work together to control the other main sources of pollution, thus ensuring the environmental standards are met. And that is precisely the right approach, isn't it?
Yes.
Yeah. And that is precisely what is happening in Greater Manchester, isn't it?
In terms of this development?
No, in terms of any developments which have impacts on the air quality management areas. What is happening is the council, this council, and others, continue to grant planning permission for developments which have impacts in terms of nitrogen dioxide emissions. But, importantly, alongside that, they have in place an air quality management area action plan which focuses on reducing the impacts from, as you put it, the main sources, in this case traffic. And that's precisely the position, isn't it, here?
That is the position. But I would just like to add something which doesn't actually answer your question, so please bear with me. For a long time, we believed that air quality was going to improve. There has been a whole series of EU limit values that have introduced more stringent emission limits to all forms of cars, to limits of petrol cars, diesel cars, heavy-duty vehicles, etc. And I remember many years ago the head of air quality for DEFRA saying, oh, by 2010 we won't have any air quality issues. But what has actually happened in reality is that those emission limits have not achieved what they were set out to achieve. So we always believe that, okay, it's okay to have small increases in concentrations of nitrogen dioxide, because over time that will be counteracted by the improvements brought about by technology. We now know that's not happening. We now know that nitrogen dioxide levels are not going down at the rate at which we thought they were. They went down fairly rapidly until about 2003. And since 2003, they have more or less stayed the same. We know that diesel cars are now 50% of new car sold in the UK. We know that we've got up to Euro 5 on emission limits. That's 5 different sets of emission limits. And on on-road test suggested there is no difference between a Euro 1 and a Euro 5. So we're now in a very difficult position, and it's not just in the UK, it's in Europe as a whole, where we're finding that air quality is not improving to the levels that we thought it was. These limit values have been set to protect human health. The government is trying very hard to negotiate with the European Commission over this issue. The European Commission is looking at reviewing air quality legislation. I very much doubt that they're going to make those health protection standards any less stringent, but it is a big issue. So coming from an air quality point of view and not from a planning point of view, we're in this situation where we have these standards that are proving incredibly difficult to achieve. Now, where that sits within the planning system is quite difficult.
But does it generally mean that planning applications should be turned down in areas of high concentrations of NOx?
I believe that it would be preferable if that was the case, but other considerations need to be taken into account in the planning decision. So if I can give you an example which might be counteracts my argument, is that I believe in the London Borough of Kensington and Chelsea, so the background concentration. Is that where you live, Mr. Kingston? You're smiling.
No, I don't. I only know that Kensington and Chelsea is the London Borough that's distinguished by not requiring residents to park in zones, but allowing them to drive their cars anywhere in the borough. Because, of course, you couldn't go by public transport, could you?
Maybe I've chosen a bad example, but in that DEFRA produced background concentrations across the whole country, and those background concentrations in central London exceed the air quality objective as it stands. So therefore, you could say there should be no development in those areas.
I mean, would it be fair to say in major transport corridors, I mean, it's the problem. So clearly around Manchester it's the road system.
It's the road system, and the vast majority of exceedances of the air quality objective EU limit value is due to road transport. So you have this very difficult situation where, health protection, which is why the EU limit value is set, versus the need for economic development. And that's why I think the location of these plants is very important. As I said earlier, if there is a reason why that development needs to be in this particular area, then the balance, which you and others do and I don't do, the balance might be different. So here, where this plant doesn't have to be here, it could be somewhere else.
Yeah.
Yes, well, Dr. Holman, I'm not going to discuss the planning issues with you, but I would like you to respond to my original question.
Can you just repeat it, please?
Which was firmly rooted in Trafford, in Manchester, and the proposition I put to you was that what is happening in Manchester and in Trafford, and adjacent borough in Salford, is that councils continue to grant planning permission for developments which in your terms would have adverse, and in some cases, with some developments, significant adverse effects on air quality and nitrogen dioxide levels. And they do so on the basis that they are working to address the main source of nitrogen dioxide pollution, that is traffic, through the air quality management area action plan. Exactly what you've described in your paragraph 2.64. That is the reality, isn't it?
Sorry, something just went out of my mind. What this actually says is this paragraph says about working with other agencies. The local authorities do not have control over the motorways. The motorways are under the control of the Highways Agency. So the local authority actually has very little means of controlling the traffic in the area.
But that's why the local authorities in Manchester entirely in accordance with the process you described in paragraph 2.6.4. Is that correct?
Okay. They are working together with other agencies, yes.
Yes. Whilst at the same time continuing to grant planning permission for development, which has impacts, and in your terms, adverse impacts on nitrogen dioxide emissions within the air quality management area.
And the National Planning Policy Framework says that you shouldn't give planning consent if it's going to be counter to EU obligations.
But you see,
So is
go back
that...
to my question. First of all, my question is correct, isn't it? You must know that that's what the councils continue to do. That is to grant planning permissions, but address the issue in the way I've described it. Yes?
The National Planning Policy Framework came in April. So a lot of those last year, before those plan applications were granted.
We've got more recent ones. But the council's approach is entirely in accordance with an approach which is the one you refer to in 264, isn't it?
Well, what it says would be desirable, would normally be more desirable for regulators to work together to control the other main sources of pollution. Unfortunately, we have no evidence that there is any control of the traffic happening. Yes, there is a Greater Manchester Air Quality Action Plan. There are action plans in many local authorities, and one of the problems is that those action plans actually haven't been very effective. They haven't delivered. And that's why DEFRA are currently reviewing and putting out contracts to actually try and understand what measures would be effective at the local area, especially in areas such as Manchester, where it is the major roads that have the problem, rather than the minor roads.
Well, in due course, if necessary, we'll invite Mr. Richards to look at the Air Quality Management Area Action Plan and see its focus on the transport-related measures, and you'll be able to see whether what I've put to you, you've not yet answered, but I'm not going to ask it again, is correct. Go to paragraph 109 of the National Planning Policy Framework, please.
So which core document is that on?
Oh, it's got the code up. 56, certainly.
Which paragraph, please?
109. You had that. Thank you, Roman. Paragraph 109 has lots of bits in it. What should be contributed to planning to contribute to enhance natural local environment. It goes on, in essence, through a series of matters. There's nothing here in absolute terms, is there? All of this is characterized in terms of unacceptable or acceptable risks. So, minimizing impacts, for example.
That's true.
And if you go to the penultimate bullet point, preventing both new and existing development from contributing to or being put at unacceptable risk from or being adversely affected by unacceptable levels of. So it's unacceptable risk from unacceptable levels of. Yes?
Yes.
And clearly, in that sense, we're not dealing with what is being put forward as absolutes, but as you indicated, I think at one stage earlier, matters of judgment. Is that correct?
That's correct. So I would suggest that unacceptable risk would probably be the where it says unacceptable risk, I think that you would judge the acceptability or otherwise of the risk in relation to the air quality objective or the EU limit value.
So are we back to saying that in your view, from the air quality perspective, once you're above, in nitrogen dioxide terms, 40 micrograms per metre cube, you are in unacceptable territory?
I would not agree with that statement, but I think
Good.
that if you're 68, you are in unacceptable territory.
Well,
68 being the highest concentration, to my knowledge, that's been measured in Liverpool Road.
yes. Oh, we'll come to all the issues about Liverpool Road in a little while. And look at what's been done there. And acceptability, of course, has been considered, hasn't it, Dr. Horn, in the regulatory framework which has been put in place by the EU and UK. And that's, of course, where the standards come from, isn't it?
Yes.
Yes. And standards are formulated, aren't they, on the basis of protecting the health, well-being of all members of society. Yes? So you don't have to be, as it were, fit and healthy in order to qualify for protection. You're protected even if you're unfit, not so healthy, or young, or infirm. Yeah. Back to the framework. If you go to paragraph 124. Planning policy should sustain compliance with and contribute towards EU limit values or national objectives for pollutants, taking into account the presence of AQMAs, cumulative impact on air quality from individual sites and local areas. Planning decisions should ensure that any new development in AQMA is consistent with the local air quality action plan. So the test being set for the development in terms of paragraph 124 is consistency with the local air quality action plan.
Yes.
I don't know whether I had reported to you any of Mr. Watson's evidence, but we had confirmed yesterday that it is no part of the council's case to say that this development is inconsistent with the local air quality action plan. Yes?
I wasn't here when Mr. Watson was giving his evidence, but my looking at the air quality management plan would agree with that.
You would agree. Excellent. Thank you. And just noting that this is referring to, in the last sentence, new development in air quality management areas. You have taken the view, haven't you, in your proof of paragraph 218 on page 4. You tell us, having referred to paragraph 124, this is relevant to the current appeal because the proposed breadth is adjacent to the Greater Manchester Air Quality Management Area. And because I know you of old, I have assumed you take, as it were, the sensible and pragmatic view that the part of the appeal site that was of interest was the part which contained the plant and the stack. And that's why you say it's adjacent to rather than within the AQMA. Is that right?
That is true.
Good.
But I know the point you're trying to make is that it's not. I'm saying it's not in the AQMA, and therefore this policy doesn't apply. But
I'm not trying to, Dr. Horn, I'm not trying to make that point. No, not at all. And if I may, I commend you for what I regard as an entirely sensible approach to this.
You don't get a higher commendation than that.
I'm serious, Dr. Holman. I think it's an entirely responsible way of approaching how the plant is is located. But of course, as soon as you say adjacent, then you've got the issue which we referred to already, which is the judgment issue, haven't you? Judgment issue of how do I proceed in the context of this plant in this location on the sensible basis adjacent to the HUMA, bearing in mind that there's no conflict with the air quality action plan. And that's all judgment, isn't it?
And I was going to say the judgment, although the policy is in the air area, because its impact on it, although it doesn't actually say that, I would suggest that that should also be taken into consideration.
Well, we had enough of the debate about the wording of the framework to prevent me from wanting to enter into saying you should have something added into it, knowing every word was crafted so carefully.
Were you involved in its crafting then?
No, I'm going to disclaim that in any direct sense at least, although I may have expressed the odd trenchant view to those who were doing it. But, just again looking at the acceptable and unacceptable, if you just go back to paragraph 120. Paragraph 120 introduces it itself, doesn't it, with the wording which I've referred to already, to prevent unacceptable risks from, yes? And it's precisely the same approach, isn't it? A judgment as to whether something is acceptable or unacceptable is involved in the process that we're going through. Yes?
Yes.
Good. So we're now going to turn to a different part of the policy, so I'm not sure if that's a convenient moment.
I think it probably is. Yeah. Yeah, 12:58. Yeah, that would be spot on. So can we take a 45-minute break? Come back with 2, 3. Thank you. The only place you go down to